You've been sued. You just received a complaint served on you by a process server alleging a variety of different legal theories, including negligence. What do you do? Hi, my name is Peter Lamont, and I'm a personal and business law attorney practicing here in the state of New Jersey. Today I want to talk to you about how one responds to a complaint. Now, when an attorney has a client come in and the client says, I need your help, I've just been sued, what do I do? I've received this complaint and it alleges all these things. What's the next step? Well, in typical lawsuits, the next step is filing of an answer. Now, what does that mean? Well, an answer is a written legal response to the allegations and facts set forth in the complaint. It allows you as a defendant to admit or deny the allegations, and then to include your affirmative or separate, as they're called in some states, defenses. So in other words, let's assume for a second that you are sued as a landowner and it's a slip and fall case, and the plaintiff alleges that you failed to maintain your property in a safe condition, and as a result of your negligence, they sustained an ankle fracture. Now, you don't own the property. You have nothing to do with it. They've got it wrong. They've got the wrong person. So when you go to your attorney and you say, here's my complaint, what do I do? Well, that attorney is going to file an answer. The attorney will deny all of the allegations, and then as part of their affirmative or separate defenses, the attorney will say, this property is not owned by us. Now, that doesn't mean that you automatically get out of the lawsuit, but you preserve your rights down the line because you've answered in that fashion. Now, if you were to admit an allegation, typically it becomes very difficult to unadmit something that you've already said is true. So it's always a good idea to speak with or retain an attorney when you've been sued. Now, aside from filing an answer, there are other things that can be done to get you out of the case if the facts are such that you are permitted to get out. And those other things can be anything from pre-answer settlement discussions to something called a motion to dismiss. Other states allow you to file something called a motion for summary judgment in lieu of an answer. And those topics are discussed in separate videos. And I don't want to throw too much information at you right now. I just want to explain the basics behind an answer. It is a formal written response to the allegations contained in the complaint. Typically, each state will have a different time period within which you, the defendant, has an opportunity to provide an answer, to file it with the court and to serve it on your adversary. So, again, it's always a wise decision to consult with an attorney because in the event that you miss that deadline, you could have a default entered against you. And that's basically the court saying, well, you didn't answer in time, and therefore, just based on a default, your failure to respond, we're going to award a judgment to the plaintiff. And you definitely don't want that to happen. Now, if you have any questions about answers or lawsuits, or any legal questions for that matter, I want you to pick up the phone and give me a call. I'm here to answer your legal questions, and I do so on a daily basis. So any sort of question that you have or inquiry, pick up the phone and give me a call. I can be reached via telephone at 973-949-3770 or via email at plamont, that's P-L-A-M-O-N-T, at peterlamontesq.com. Thanks for watching.